we begin tonight with the first of a two-part conversation you'll only see on NMPBS between executive producer Jeff Proctor and Alexander Ubaez, U.S. Attorney for the District of New Mexico. The broad frame for this discussion is the ongoing federal investigation into an alleged scheme that saw Albuquerque police officers working illegally with at least one local attorney and his paralegal to make DWI cases go away. Ubaez is overseeing the investigation, which crashed into public view on January 18th. That's when FBI agents raided the homes and offices of that attorney and his paralegal and executed more search warrants at the homes of some of those cops. To recap some of the fallout so far, 2 officers have resigned, several others are on leave, and the Bernalillo County District Attorney, Sam Bregman, has dismissed 200 DWI cases and counting. U.S. Attorney Ubaez took the unusual step in January of confirming the investigation in letters to Bregman and Police Chief Harold Medina, but he has not spoken publicly about it until now. He kept most of the details of the investigation close to the vest, but he spent nearly half an hour with Jeff talking about process, the public's right to know, and more. Part 1 of their conversation begins with one of Jeff's least favorite phrases in the English language.
Alex, thanks so much for joining me today, and welcome back to New Mexico in Focus.
Thanks for having me.
Okay. I would like to start with a phrase that I have heard entirely too many times in the course of doing journalism for 20 years. The phrase is, we can neither confirm nor deny the existence of an investigation. So that's sort of the default setting for the U.S. Attorney's Office. Why is that?
There's a number of equities that we protect, in justice. We are entrusted as prosecutors, but especially in Department of Justice prosecutors, with this huge power, right? Even to know that you're being accused or somebody's being accused of a crime, right? It has a huge impact on their life and the people around them. And so in protecting the rights of people, we have to always balance a number of things when we approach any case, right? And so this answer you've doubtless received, and years of speaking with us about either investigations you suspect are ongoing or cases even that might be pending, yet we're not going to give you anything on it until it's sentenced. And so we protect a number of equities here in the Department of Justice. The first, of course, is a person's rights to a fair trial, right? So if we start getting out in public and talking about things that we haven't proven in court, then that person's jury pool is hearing these things. It not only makes it more difficult for us to pick the jury in the first place, but it makes it more difficult for a person to have a fair jury, right? Someone who's going to hear the facts for the first time from the parties in a situation where a judge is overseeing and determining what is legal to come in and what is not. So we want untainted juries. The second part is people's rights to privacy, right? So if you're the target of a federal investigation, I'm not going to tell other people because that could affect your job, it could affect your marriage, it could affect your friends. And so this is a thing that, if released publicly, has a huge and deleterious impact on your life, right, as a defendant. And then, of course, we balance these against a couple other interests, including our rights, our interest, our job, which is charged with public safety. So we have to balance the safety of the public, the needs of the public in securing their safety against whatever crime or allegation it is. And then finally, there's the interest that you protect here, which is the interest of the public to know broadly what their Justice Department is doing, know that we are doing the job and not sleep at the wheel, and know that it's functioning correctly. And so we have these 4 areas that we have to protect in every single case. The clearest line that we've found to draw here is the one of indictment, right? So when we have taken it to a grand jury, or we have taken a complaint to a judge, and that person or that grand jury has said, we are finding by probable cause that these offenses happened. That stopgap has been crossed in the system, and we are formally accusing people of a thing, right? We take our responsibilities in advance of this charging decision very, very seriously. There's a lot that we do in advance of charges being brought against someone because we know the impact it has on people's lives. But even then, you'll see in our press releases and in our discussions, in our answering of questions, even after charging, we hew very closely to just the things that we have said in courts and on the record. Because when we say things in courts and on the record, we are responsible. We are held to account for the veracity of those statements in front of a judge. The same can't be said to be true about statements in public, from public officials, from politicians, from law enforcement, but it can be said to be true when we're offering testimony in court, when we're offering evidence in court, when a court has deemed it admissible. And so for that reason, even then, after we've charged somebody, we are still very cautious about commenting on a case. Until finally we've convicted, we've sentenced. And that's when we give our press conference, that's when we do interviews, and that's when the public gets to know a whole lot more about what happened than from the initial indictment or complaint.
I appreciate the explanation. I think that there's a possibility that the next time I receive that response from your office, I will be a tiny bit less irritated. Does that policy, does that present any challenges for you as a federal prosecutor?
Sure, it does. I mean, so we're balancing these things, right? And so the fact that we want to protect a person's right to a jury, want to protect their privacy, doesn't erase the fact that we know the public needs to be protected, first and foremost, and they need to be informed about what we are doing, that we are doing it, that they can trust that we're doing it, and that it'll come to a just result. And so it's a constant balance.
Gotcha. So in this particular case, this ongoing investigation into possible misconduct by Albuquerque police officers and others, you decided to go a slightly different route. You wrote letters to the district attorney and to the police chief in which you did confirm the existence of this investigation. I'd love to have a little behind the scenes on what led you to make that decision. What sort of factors went into sort of detouring from the usual policy?
Sure. As with any policy, our policy on discussing cases has exceptions, right? This is how lawyers operate within the realm of exceptions. And so there's a couple that apply to us when we're dealing with cases of this, this amount of interest from the public or interest to the public. The U.S. Attorney in any given district or the Assistant Attorney General at the Main Justice have the ability to find exceptions. So they can look at it, they can look at a case or an investigation and say, there are reasons why we should confirm that federal law enforcement is doing their job here. Or there are reasons why we should release information that have to do with protecting public safety. And so in a case, for example, where people see a bunch of folks wearing FBI and bright yellow on the back of their jackets go into a house, but there is no other explanation for why or when or how, there is often a public interest in knowing this is actually law enforcement. They're actually authorized to do this, and this is part of something that is happening, and we can trust that there is a process here, and not just rogue people who bought jackets, at Spirit. And so, when we discuss cases, and this one with the investigation you're referring to, we confirmed early on federal law enforcement activity at various locations, as we were asked by the public. Because we felt that it met that requirement, it met that need, which is people are seeing federal law enforcement activity happen, and they don't know what is happening. And so for us, that small bit of confirmation allows us to tell the public, don't worry, this is authorized, we put thought into it, and we are working on it.
Sort of an authenticity stamp, if you will.
Yeah.
I want to talk about a word that you used in those two letters I just referenced to the DA and the chief. You nodded toward the tension between the public's understandable desire for information about something like this and the secrecy needs that you just sort of described. Let's pull out a little bit from this investigation and talk broadly, how do you balance those two principles? What goes into that?
A lot goes into it. Everything that we do in our job is a careful balance of the various needs that we protect. It's really unique being, especially a federal prosecutor, but being a prosecutor. Amongst all lawyers, our job is very different. It's distinct in that most lawyers, they take a case or a client, and that is the interest that they represent, right? They're being hired to exercise that person's interests at the expense of all others. That is never ours. And so in everything that we do, we are thinking about all of our clients. For the Department of Justice, that is the United States, right? And for us, what that means when we walk into a courtroom, the equities that we protect are not the government's, as often courts like to refer to us. The equities include not just the people on the streets and the members of the community, but the jurors themselves, the defendant himself, his attorney, the judge. All of their interests as members of our community are balanced together. And so as a federal prosecutor, we deal daily with the balance between different interests for different people, what is best for the community and public knowledge versus what is best for an investigation, and most importantly, what protects the rights of the target or defendant as well, right? Because until the person's accused publicly, the person is considered innocent. right? They should walk free from any public aspersions over what they may or may not have done. And so when we do our job, we try very, very hard to maintain that protection, not just of the public and the safety concerns, but of defendants too, and their interest in privacy, their interest in walking free until a grand jury or a judge has said there's probable cause to say you did this thing.
And of course, the innocence presumption still attaches at that point, even after indictment.
Absolutely.
So it's been 7 weeks now since what you just mentioned a moment ago, since y'all kicked some doors in and executed some search warrants. I think it's important for people to hear you say, what can you tell us about this investigation at this stage in the proceedings? What's the full extent of what you can say?
Well, Jeff, I can't confirm or deny the existence. No, so we have obviously confirmed that an investigation is underway. We've confirmed locations in response to public and media inquiries where federal law enforcement action occurred. And from the letters that we issued to both the district attorney and the chief of police, we've confirmed that they knew about the investigation, but were not read into its full extent, right? And that's because when we are protecting an ongoing high-level investigation, there are often partners who we work with, but we don't share everything with. And so, as you identified, we're going to let them know as much as we can for them to fulfill their own duties. So, in our letter to the district attorney, we acknowledge that every prosecutor has a responsibility, a constitutional one, under Brady and Giglio, to protect the process by identifying certain we call Giglio conduct. And so, when we run up against these other responsibilities, we share what justice demands. But on the other side of it, we keep as much in-house as we can until we're ready to level an indictment.
So for people who don't know what Giglio material is, that we're essentially talking about information that could impact a witness's credibility in court, right?
That's correct.
Okay.
There's a broader constitutional protection called Brady, so exculpatory information, a subset of what Brady, and so the constitutional requirement for Brady is obviously that if we have something that says the person we were thinking did something did not do it, then we have to disclose that evidence. A subset of that is Giglio, as you identified, which is if we have information that can be used to cross-examine or impugn the credibility of one of our witnesses, we should disclose that too. And so when we run up into these either constitutional requirements or protections, again, we protect the defendant too. And so that's where we work with the DA. This is where we're sort of working in a similar but alternate track with the chief of police. But again, the letters show that while they were aware of investigations, they are not aware of the full scope.
Gotcha. I want to ask another question sort of related to balancing. Mm-hmm. The law enforcement community in New Mexico is relatively small, relatively tight-knit. Obviously, your office and the FBI conduct joint operations with APD, the county sheriff's office, and the district attorney's office all the time. Mm-hmm. How would you respond to public concerns about the possibility of one of your investigations being contaminated or compromised because of these relationships that can develop?
Yeah, there's always a concern that information can leak. As a law enforcement investigator, there's always a concern that information can leak before you want it to. This is why for step one, we work in sort of insulated circles. When we're working with cases, we deconflict, it's called, which makes sure no other law enforcement is working a similar case against a similar person. But we also wall off, right, as is identified in these letters sent to the DA and the chief, non-essential law enforcement components from what we are doing. And so while there is always a worry that things could be leaked, we also operate in a world where we have to trust each other to move forward, right? And so amongst federal law enforcement, it is a very tight-knit community here. We work all the time and constantly, and also with our local partners, to face the many challenges we have here in New Mexico. And so it's a tight rope to walk, but you have to understand you got to take some risks if you want to get the right cases and the right people. And so we balance those risks. We manage and mitigate possibility of disclosure before we want a thing to be disclosed. And we trust. We rely on each other day in and day out. Our federal law enforcement partners, put their lives in each other's hands. And so it's with this trust that we go forward on these kind of investigations.
There is a little bit of a needle to thread in a case like this. Obviously, the nature of the federal inquiry here is criminal. It's a criminal investigation whose stakes, of course, are someone's freedom at the end of the day. On a parallel track, you've got an administrative investigation that the police department itself is conducting, the consequences of which could be someone's job. For example, when a police officer is interviewed in an internal affairs investigation, he's read what's called a Garrity warning, which essentially is him saying, I'm giving up my Fifth Amendment rights here. I'm going to talk to you and answer your questions. You wouldn't be able to use any of that in your criminal proceeding. How do you make sure, broadly speaking, again, not just in this investigation, how do you make sure those two things stay separate?
Sure. And so we have a lot of, we invest a lot into protecting our investigations, both from being leaked or public knowledge, but also legally, right? So like it's our job to both present the case and win it. And so if we present a case, but there are constitutional problems with it, we have not done our job, which means and there are many stopgaps that we put in place to ensure that we are advancing a legally defensible case. In some cases, that'll mean we have filter teams who are entirely a separate team of both agents and AUSAs. A filter team works in a situation where there might be something that the prosecuting team shouldn't have, right? And so we will often use filter teams to take a first read of whatever it is that we're looking at, and the filter team can then pass on non-tainted evidence to the prosecution team to go forward with. And so it's by essentially doubling the resources we invest in any case, but we do it again to protect the integrity of that case and its presentation to the jury.